Good morning. We are going to start today with exception number 2 for murder. That is section 101, exception 2. Okay. Here we are discussing how culpable homicide is not amounting to murder. Okay. Culpable homicide is not murder if the offender, in the exercise in good faith of a right of private defense of a person or property, exceeds the power given to him by law and causes death of the person against whom he is exercising such right of defense, without premeditation and without any intention of doing more harm than he is necessary for the purpose of such defense. Okay. Now we have to first understand the right of private defense, which we have discussed in the previous lecture of general exception. Okay. Now what is right of private defense? Law cannot protect anybody everywhere, isn't it? Therefore law should not be taken in hand by all the people. But sometimes it happens that law is not able to protect you there. You are not in a position to contact or have a recourse to public officers. So what law says? Okay, you can use reasonable force. If there is an apprehension, then you can use force. You can defend yourself. Don't attack. Don't be assailant. Don't be attacker. You can defend yourself. And that right is been given to us under BNS. Previously it was given under IPC. Okay. Now if what the law says, when apprehension is created, then you are having a right of private defense to defend yourself. How much you can defend yourself? How much the attacker has created the apprehension. Okay. Now there are certain circumstances where law allows you to kill that person. You are having two rights of private defense. One is the right of private defense for body. The other is the right of private defense of property, of yourself and of others' property also and others' person also. Now if the assailant, the attacker, is creating an apprehension of death, creating an apprehension of grievous hurt, creating an apprehension of rape or kidnapping or unnatural lust, a list is there. Similarly, a list is there for telling the circumstances that in a right of private defense of property also you can kill the person. Means in these circumstances you can kill the attacker and you are going to come within the right of private defense. If you are able to show in the court that the attacker had created this kind of apprehension, then you are allowed to kill that person and you are exempted. You are exempted only when those circumstances are there. But see, if there is no such kind of circumstances, then how much force you can use? What can be called as a reasonable force? Then what law says? Law says you can use reasonable force, means you can defend yourself, you can protect yourself. Don't exceed your right of private defense. Means leaving those circumstances, you are not allowed to kill the attacker. Okay? You can use reasonable force, you can defend yourself. But if in certain circumstances where you are not allowed to kill the attacker, you kill him, you cause the death of that person, okay, then you are coming under this exception. Okay, means it is not a murder. It will remain as culpable homicide. I'll repeat again. In BNS, under general exceptions, we are having right of private defense of property and body, and there are certain circumstances where you are allowed, while defending yourself, you are allowed to kill that person, kill that attacker, and you are coming under the right of private defense, you are exempted. But leaving those circumstances, you are not allowed to kill that person. But if you kill him, then you are exceeding the right of private defense. Okay, you are exceeding the right of private defense, then you are coming under exception number 2. And here it is not murder, it is culpable homicide. But for that, what are the essentials? The essentials are you are going to exercise the right of private defense in good faith. Good faith of the right of private defense of person or property. You are exceeding that power. You are causing the death of that person. But here you are within the right of private defense only, because you have not done it in premeditation. There is no premeditation and without the intention of doing more harm. Means you wanted to defend only, but it happened. You exceeded. Therefore, you were in good faith. You were exercising the right of private defense. There was no premeditation. There was no intention. And the assailant had started first. He had attacked you. Therefore, you are exercising the right of private defense. In such a circumstances, it is not murder, it is culpable homicide. Okay, this is exception number 2. Now, exception number 3 is what? Culpable homicide is not murder if the offender, being a public servant or aiding a public servant acting in the advancement of public justice, exceeds the power given to him by law and causes the death of doing the act which he in good faith believes to be lawful and necessary for the due discharge of his duty as such public servant, and without ill will towards the person whose death is caused. Means here what has happened, the police officer or the public servant who is having certain powers to control some person, to use some reasonable force against the person, at that moment what he has done, he has exceeded his powers. Now when he exceeds his powers, we'll take an example of a police officer. If a police officer exceeds his powers and kills that person, then okay, he exceeded the power. Therefore, it will not be murder, it will be culpable homicide. But for that, what are the essentials? The public servant must be acting in good faith. Being a public servant, aiding a public servant, acting in the advancement of public justice. He exceeds the power, and while doing that, he is in good faith. He is not having any animosity or anything. So he just exceeded his powers and the death has taken place. So there is no ill will towards the person. There is good faith, and if the public servant exceeds his powers, then that is not a murder, that is a culpable homicide. Okay, now we know about encounters. Okay, now legal encounters we are talking about. There are certain circumstances where the police officers are allowed to kill a person. When he attacks the police officer, he is accused of an offense which is punishable by death and all, and he is attacking the police officer. He is doing something wrong act. He is trying to run away and all. Then there are certain rules, there are certain restrictions also, that while killing the police officer has to be within restrictions. So he is within restrictions and all, and if he does cause the murder of that, death of that person, then the police officer is not liable for murder, because he is doing a legal act here. He is justified in doing that. Okay, this will be lawful. He may have done an encounter, but that is a legal encounter. Therefore, the police officer is not liable. This is not murder, neither a culpable homicide. It is a justified act. But if a police officer intentionally, with a ill will, without good faith, for certain reasons, with a plan, with a meditation, with a guilty mind, if he kills some person, kills the person whom he has arrested, and there is no good faith and all, then this will amount to murder. This is not an encounter. They may show it, they may have a report to show that it is a legal encounter, but this will be murder, because there is no good faith, there is ill will. It is something called as, you can say, fake report. So here the police officer will be liable for murder. But here we are talking about a good police officer who is acting in his duty. He is doing his public duty. He is trying to control the mob or doing something for public advancement, for the public interest, for public justice, and in that circumstances he exceeds his power. He exceeds his power and kills A. But while killing that person, he was in good faith. He was not having any animosity. He was not having any ill will towards that person. He wanted to just control at that time. But at that moment, at that, you can say, heat of moment, he exceeded his powers. In such a circumstances, the police officer or the public servant will come under exception 3. We'll see again, culpable homicide is not murder if the offender, being a public servant in the advancement of public justice, exceeds the power given to him by law and causes the death by doing an act which, in good faith, believes to be lawful and necessary for the due discharge of his duty, and as such the public servant, and without ill will towards the person whose death is caused. Here this is important, without ill will, and that is necessary. He feels that whatever he is doing, that is necessary for the due discharge of his duty as a public servant. Then such a police officer or a public servant will not be liable for murder. He will come under exception 3, and that is culpable homicide not amounting to murder. Okay, till today we have seen how many exceptions? We have seen 3 exceptions. 2 exceptions are left that we are going to see in the next video. Okay, bye bye. See you.